Good morning and thank you for joining us today. My name is Tracy Black and I'm the Chief Commercial Officer at the CBI. And we're here to discuss the Employment Rights Bill, the centrepiece of the government's Make Work Pay agenda, which they describe as the biggest change in a generation. The bill completed its passage through the House of Lords this week, and the final step to come is to reconcile the differences between the versions passed in the Commons and the Lords, which will happen over the next few months. With a final version of the bill in sight, it's a great time to take stock and think about what this means for businesses. So to help with that, I'm delighted to welcome Matthew Percival, our Future of Skills and Work Director, and Monica Atwell, Managing Partner and Head of Employment for Clark's Legal, a firm that we thoroughly enjoy working with. But let's start with day one rights. Matthew, what is it we need to know?
Well, I think there's a mix of things here where there's some bits that are really quite well known and then maybe a few bits that fly slightly under the radar. So let's see if we can cover a bit of both. We have the headline, most people will know. The idea is this is getting rid of the 2-year qualifying period for unfair dismissal that currently has been consulted on and a bit of focus of some of the media attention last summer. You remember there was speculation about how long might a probation be in the future. And so that's the most focused on bit is getting rid of this qualifying period. The practical implication for an employer then is, well, you were probably thinking about treating people fairly at all times anyway, but there is now an increased risk of an employment tribunal from day one.
Do we think employers are going to change their recruitment over the next 2 or 3 months at a time when we're looking for growth? Is this going to have an impact?
Look, and the government would say they don't want that to happen. They want businesses to have the confidence to hire. You know, ministers have said that privately, they've said that publicly. They don't want this to affect the confidence to hire. They think that they can protect that confidence to hire while still allowing a day one right to go to an employment tribunal. Now, I think there's a gap between our members and government in terms of how realistic they think that is. Our members have been quite worried in saying we're not sure you can reconcile those two commitments.
Monica, do you want to add to that?
Yeah, I think, Matthew, you're right. I think on one hand, we're giving advice to get the recruitment right, but lots of employers take risk and to their benefit, and that may curtail their appetite for risk. Again, you can mitigate that by perhaps telling somebody, I'm taking a risk on you, you've got to meet these measures within the first couple of months. But I think it will impact employers' decisions.
The second topic is around guaranteed hours. Matthew, why don't you explain that to us a little bit? What do they mean when they say they want to address guaranteed hours?
Yeah, this one's a biggie. It's one of those ones where you think back to the general election and the slogan was we're going to ban 0 hours contracts. And I had a lot of companies that said to me, we're not worried about a ban on 0 hours contracts because we don't use 0 hours contracts. But this change around guaranteed hours is going to do so much more than that. Because what it's really doing is looking at the hours that your employees work, and if the number of hours that is guaranteed in their contract is different to the number that they're actually working, then you're going to have a responsibility to offer them a new contract that averages out the hours that they've actually worked and guarantees them in the future. So think your things like your overtime. We've been having conversations with government that says, how would this play out if somebody's off sick and the work that someone else does is actually covering sickness absence rather than as extra work in the business? You can't guarantee those hours for 2 different people. So there's all these sorts of practical challenges. The caveat that we have is it's going to be guaranteeing regular hours, and regular hasn't been defined yet. So there might be some wriggle room in that helps to make this more practical for employers.
Monica, do you want to add to that?
Yes, I agree that it is a really problematic area at the moment. And so we are entering into consultation and therefore I would be encouraging companies to actively consult. And that's looking at what their practices are and running those numbers, because this will include people that genuinely want to work part-time. And this is a government that will be increasing the the ability to work part-time. Employers will then need to look at what this means by analysing their numbers and whether using fixed-term contracts, which may be opposite to having long-term employment, might be a possibility, or looking at annualised hours. So these are things that are possibilities, but without the detail, no employer can really properly plan.
And are there particular sectors that are going to be hit harder from this than others?
Absolutely. I mean, we're all getting ready, hopefully, for a really good Christmas party. So you're looking at hospitality, agriculture, where there is seasonal influxes of the requirement of work, and there's not enough leeway to allow for the ups and downs of, seasonal requirements.
Got a few questions coming through, and there's one that's come up quite a lot, but I'll start with Amy, is asking, how does this apply to temporary workers, and what is the obligation for the agency they work for? Do you have any thoughts on that, Monica?
So it's anyone that's on a low hours contract. So it doesn't matter if you're from an agency, you will also be in the same situation. What will happen though is the end user will make an offer. So there'll be a direct relationship between the worker and the end user. And it's such a good question, because what organisations will have to look at is those supplier agreements, because they might be hit by an agency referral fee. So those workers are definitely included.
So anybody's thinking, oh, well, I'll just go through an agency, I won't hire them direct myself, that isn't going to be an option.
And there's quite a lot of anti-avoidance measures in the bill to literally stop people not getting guaranteed hours and increased guaranteed hours.
And I think that's one of the biggest challenges in our conversation with government over the last year or so, has been each time we've tried to explain the tension at the heart of this initial policy is a bit assuming you can guarantee all hours and therefore you don't need any other flexibility to run your business in that way. Whenever we go back and explain, well, actually businesses do need some flexibility, it's right that you should make sure that's not an abusive form of flexibility, but there is always some flexibility needed. Government faced a choice when they put the bill forward. They knew that either they could write something quite simple and not have agency workers in scope, but the number of agency workers would probably go up as businesses would get more of their flexibility from agency workers, or try to draft something fiendishly complicated about the responsibility of an end hirer to offer a direct employment contract to an agency worker and interfere with the temporary agency market in that manner. And they've gone down that route.
Victoria's asked us, how far in the future do hours have to be guaranteed?
I don't know the answer.
It's a permanent factor, is it not?
Once the guaranteed hours is saying you are guaranteed going forward this amount of hours based on the reference period. We think it's 12 weeks, and that will be indefinite. Except you have another reference period, and if they work more than that, they get a bigger and better offer.
But that's why it's a ratchet, because you can never work fewer than the number you were guaranteed last time, because you were guaranteed them, but every time you take on some overtime. So some of the things we'll be looking to try and do in those consultations around reasonable will be, surely we need some sort of exemption that says if someone just happened to do one overtime shift covering some sickness absence in a year, we're not going through doing a new contract, because it's not a material change. If it averaged out they worked one more hour than their contract guaranteed, is that enough to trigger us into a new contract? It would be different if someone had 4 hours in their contract and they were working 30 every week, right? You'd probably be thinking, well, that sounds like quite a more sizable change, and you might think that needs to be reflected. So could there be some sort of differences there? But it is worth flagging. A number of our members would also be saying, we're short of people right now. And actually, we're already having conversations with our staff trying to say, well, you've been working more hours than you've got in your contract at the moment. Do you want a new contract that could increase it? And there's lots of businesses trying to do that to help address some of their shortages, because they're trying to lock in the availability to their staff that they need.
Has there been any analysis done by government or any of our members know of like how many workers on low hours want more hours?
I think, well, look, I was with a member the other day who said that they already do a version of this, at least a version of proactively monitoring the hours, having conversations with people who work more hours regularly than not, and most of their workers don't take up the new contracts, or I guess the business isn't processing and offering a new contract, but they're having a conversation about it. And some of the figures we've heard are really quite high in terms of the proportions of people who are not taking that further and turning it into a new contract offer and signing a new contract. Whereas I think government's expectation is that most people who receive it are going to want it. Yeah. And so an element of this might be only once it starts happening will government really believe the data when they start seeing how many of these offers are being made. And a big point for us is just trying to explain, in a way, all employment enforcement is bad for workers. Sounds counterintuitive, doesn't it? But because if your enforcement is changing an employer's behaviour, it can improve a picture for a worker. But if what you're making an employer do is jump through hoops to prove they were doing something they were already doing, then you're just wasting money that can't be spent on hiring more people, paying them more, improving their benefits, delivering more training courses, all those other good things, investing in technology and the rest of their business, all the things we're saying we want businesses to do. If there's money tied up in enforcement that wasn't necessary, then that's not good for us. So money tied up making contract offers to people that don't want them, maybe even if they've turned the last one down and said, look, I don't want that, but you've still got to go back to them later with another offer and say, well, it's happened again. I'm sorry, I know you said no last time, but I've got to make the offer. You could see how some people will start to get a bit miffed at, I feel like I'm wasting my time, what are we doing? And even some of the workers might be feeling that.
They might feel pressurised. They might be saying, I've made a flexible working request. I want to work low hours. I like doing these hours. I actually like saying no sometimes to work. Other things are more important than work sometimes. And you're constantly pressurising me.
Trade unions. Now, whenever you sort of put business and trade unions in the same line, people think it's got to be contentious. But we know we've got plenty of members who have got very strong and constructive relationships with their unions. But there are a lot of changes going to happen here. Do you want to sort of rattle through some of the big ones that they should be aware of?
There's a big incentive for employers to engage with their workforce. And if your workforce wants a trade union, then you should be engaging with that trade union. As you've said, a number of our members would say they have productive and constructive relationships with their trade unions. But just like businesses are on a spectrum, they'll get businesses who have got really great reputations and businesses that are maybe have a more challenging reputation and maybe get more negative profile. Trade unions will be exactly the same. They're a spectrum. They're a group of people, and they'll be one trade union will be completely different to another. So there isn't a single vision of a single experience that's uniform across all trade unions. And so businesses need to be ready to deal with the changes that are coming. But from a perspective of, we agree with the goal of government here, which is that you should be engaging with your workforce. What feels slightly different with this batch of changes is there's more of an implied assumption that in all situations a trade union is what's needed, rather than your workers being able to choose so much.
So this is really significant shift, and what we would be saying practically is that unions will have access to your workplaces by next year. So they will be invited guests. So employers will need to treat them like guests. And so it's about knowing the unions and setting the discourse right from the start of how you want to work, because there is quite a lot of rhetoric in union information, and what most employers will say when they have good employee relations is that they really understand where we're coming from. We have good negotiations, there's good compromise, there's good solutions. But for employers now, you have to supercharge your employee engagement now. You have to have an effective employee forum, which is representing the voice of colleagues, but also that they understand the needs of business. And your reps will have to be highly trained. And that allows you to be in a much better position to be able to have really good discussions and with the union as well, to sort of say, well, actually, this is what our colleagues want. So I think it's a really good time. And, you know, most employers will say employee engagement is really important. So it's we're not asking you to do anything particularly extra.
One of the questions we've got here is, will we have to open the door to multiple unions at once?
So a union will have right to access. So there may be lots of unions with their stalls out in your workplace. Once a union is recognised, you can have agreed to recognise several unions. Some employers do, and it works really well. Or you could have just one union. And this is the complication, that what you want is the variety of colleagues' voice to be truly represented. And that needs a lot of careful thought. Once you agree a union, it could be one or two, it could be for different parts of the business. You know, a union can be recognised in a unit, and that could be a department, a building, a division. So there's quite a lot of complications about who's being recognised and for what.
And then there's a straightforward question, can we say no?
No.
One of the other things I do for the CBI is I'm one of the employer representatives on the board at ACAS, what ACAS calls its council. And the council has a special role in helping to try and guide and develop its code of practice and its guidance and advice on how these things should be handled. And so whether it's through the public consultations or with government, or when ACAS comes to consult on what it puts out in codes of practice and guidance, there are routes there to try to have conversations that get it away from just a conversation about rights and more to what does a total vision of what a responsible conduct by employers and trade unions looks like, and a vision for what does a good relationship look like that supports the economy, supports jobs, supports growth between employers and trade unions, rather than it just being a narrow conversation about what rights do trade unions have against employers.
Something that definitely gets a lot of people's fired up is obviously around fire and rehire. Now, the sad fact is not all businesses thrive all of the time, and therefore restructuring has to happen. And I don't think any leadership team welcome that or look forward to it. And we obviously would encourage all companies to do that in the right type of manner. But the reality is there are some firms out there that have had front pages for not doing it the right way. So this has been pretty much central, I think, to a lot of the bill, hasn't it? It's been addressing these type of issues. Matthew, you know, what's the work we've been doing there around this? And so where are we up to on it?
Well, government would say its core objective around this is to make sure there's always the consultation that there's supposed to be when there's restructuring. And I don't think our members would disagree. You know, they have consultation obligations. They say to us, we take those obligations seriously. What the bill would do is replace that conditional ability to act with an unconditional veto for unions and workers, potentially even an individual worker, to object to the change that you're saying is required. And then you can't make that change without breaking the fire and rehire rules.
This is frightening because this whole idea of, you know, the clue is in the title, firing and rehiring. So you're giving somebody a job with the tweaks in it. Some employers may say, well, that's going to be too complicated. I can't wait for getting people's consent. I am going to change those jobs significantly, so now you're falling into redundancy. And if an employer has to rely more on redundancy, they might be looking at their enhanced terms and looking to change those. So there are some quite negative consequences if this is not managed properly.
So that's it from us. Thank you so much for joining us today. I hope you found that really useful. I have to do a big thanks to Clark's Legal for giving Monica to us this morning. I think you'll all agree that she knows her stuff inside out. Your 2 actions: go away and put a plan together. And as you're working through that plan and you discover things and things come to light, please share them with Matthew and his team. Thank you very much, and we hope you join us at our next one. Thank you.